afternoon, fellow citizens. Welcome to the Citizens Chat Show. This is the episode that is constantly going on with, but we are here. The Citizens Chat Show is live today, and we are running on our YouTube space, the Civic Space TV, but also on Facebook. Equally, we are on Facebook Live, then Twitter, on into the lockdown and happening, but we have to push on as Ugandans, as citizens, and I hope you're staying safe there. My name is Masesa Demiano, and the discussion today is, do we have enough constitutional safeguards against unfair trials, torture, and inhuman treatment for protection of the dignity of Ugandans? This is happening. These are the conversation that is events that have been happening, the and inhuman issues that have been happening with our suspects that they put into the custody. So we want to handle is quite a lot of people now with the legal brains that will help us dissect this topic very well. And to begin with, my guests, I will start with Master Munduru. She's the programs manager, constitutional governance at Actionaid Uganda. Yes, thank you, Masi. And while you're making your submissions, you try to ensure that your camera is on for visibility, because it's a TV program. Then joined on also as a guest is Robert Kirenga, the Executive Director with the National Coalition for Human Rights Defenders. Bob, you're welcome, sir.
Thank you very much, Demiano. Good to be with you here.
Yeah, thank you very much, Bob. And also Sarah Bireete, she's the Executive Director with the Center for Constitutional Governance, but also a regular panelist with us here. Sarah, you're welcome.
Thank you, Demian, and good afternoon, viewers.
Yeah, thank you. We are waiting for Jude Byamukama and also Elison Karuhanga, who will join in shortly, but because of time, we need to push on. But right into the discussion, I just want, because we are into Africa, and is one of the countries that of that tech issues happening in South Africa. I just want us to have at least a minute of each from each of the panelists to just have your take on. First, I would want to start with Masi. What is your take? What do you think about South Africa and the rule of law being under check? Just in 1 minute as we progress.
Well, I think for me, what's happening in South Africa is more about the arrest of the former president. It's really a battle of the poor against inequalities and against so many issues that have been, hanging in balance. The infights in ANC, the issue of the COVID-19 crisis as well, the economic inequalities that exist in the country that have been, avenues of tension in that country. So what people are doing now is just to push back. So I do not think that what we see happening is really hinged on the former period of inequalities using this opportunity. So for me, that is partly people taking back their power and pushing back and just sending a message about the inequalities that they endure by the day. I don't know, that's my opinion about what's happening in South Africa.
Thank you very much, Masi, on that one. Robert, what's your take on South Africa, events around South Africa?
Thank you, Damian. I also tend to agree with Masi. Although I think that it's not enough to say it's existing inequalities, my take is that it's lack of strong institutional frameworks. Because inequalities exist everywhere, even here in our own society. We have made the gap between those who have and those who do not have is quite high. But we can't take the law into our hands and say we are going to storm the different captains of workshops of industries, hardware shops, and start stealing when you have institutions that are supposed to maintain law and order. So for me, one thing is that South Africa has not yet developed very strong institutions. Yes, inequality exists, but still, if you had strong institutions, they should be able to identify those areas that can cause human security. And because they've taken it for granted and have not looked into the broader aspects of security, now they can now see the chaos they are witnessing. I don't think it is to do with the love of Jacob Zuma. Yes, Jacob Zuma is an influential former president, but the country is bigger than an individual. If they had concentrated on building institutions and addressing those issues of inequality, right from the time they got their freedom, I think they would have avoided such chaotic scenes that we continue to witness today.
Interesting. Sarah, your take on this?
Yeah, I will not differ much from the other panelists. I think the arrest of Zuma provided a spark for the people to demonstrate against extreme inequality, the sharp divides between the blacks and the lives of the political elite now who have joined the former apartheid clique. It's a shame that ANC, which has been in power for 27 years, forgot the foundations of the struggle and fight against apartheid. The struggle against apartheid was for both economic and political rights of the majority of the people. It was about universal suffrage in elections, one man, one vote, as well as economic rights that include land reforms, access to quality education, fighting unemployment, which is now at 32%. And all this divide was worsened by the COVID measures and extreme lockdown because of the severe pandemics that South Africa was facing. So you have people starving in their houses, locked up, and looking at the privileged class enjoying the luxury and economic stability that we know South Africa to be about. We know that when our people go to work in South Africa, I mean, it is, I think other than the West, diaspora, Europe and the United States, another comfortable place for our diaspora community is South Africa's Uganda, and the people working there are doing well economically. But what happens to the local people, the citizens of South Africa, and the conditions they live in, with the majority of Black people who are semi-literate and cannot access good jobs? So the arrest of Zuma acted as a spark, but I wish on that note also to underscore the fact that Africa should not bow down to leaders who want to use hooliganism to defend their impunity. Leaders should be held accountable. Zuma did rally people to riot over time instead of submitting himself and answering the questions that the Zondo Commission was asking. So every leader should be accountable for their actions or omissions in office, and we should not tolerate impunity at the verge of people using hooliganism to escape justice.
Thank you, Sarah. And just this afternoon, I think someone posted about Sarkozy and also being in prison. And I was asking now should the French also do the same, because the former president was put in. But you see, there's quite a difference in there. But thank you very much, my panelists, for having me.
Jacques Chirac was arrested in France and he served his sentence.
Yeah, interesting. And so we have quite a lot to pick a leaf on. But straight into our discussion that I want us to put a lot of focus on, events that are happening around our home. I want to start with Robert, because you're highly involved into the human rights issues and also defending, and you are at the forefront of this. I would want to ask, what are the constitutional safeguards against the unfair trials, the torture and the inhumane treatment for the protection of the dignity of Ugandans? What are those that are provided for?
Demian, thank you very much. it is true we have constitutional safeguards. What I'm not sure is whether we can describe them as enough. There's nothing like enough, Demian. People will always be demanding for more. But our 1995 Constitution amended provides for strict provisions of the law that really protect citizens from torture. For example, we have Article 20 under Chapter 4, which clearly talks about the fundamental rights that shall be respected, upheld, and protected by all organs, agencies of government. That is in terms of the human rights body, the Bill of Rights. Then when it comes to the fair trial, we have also provisions within Article 28 of the Constitution, which talks about that any person charged with a criminal offense is presumed innocent until proven guilty. Nowhere does it state that any suspect caught in any acts of violence or any act of criminal offenses will be subjected to torture. It requires also that such aspects are informed about the offenses that they have been arrested for, so that they can understand the nature of the offense. They should be given adequate time and facilities for the preparation of their defense. And of course, they should be permitted to appear before the court in person or by a lawyer of their choice. The fair trial also requires that in case it's a capital offense or the punishments of a capital nature, a capital punishment, it should be entitled to be represented, in other words, by a lawyer and at the expense of the state. And of course, he or she should be afforded a lawyer. So those are the constitutional provisions in as far as the right to a fair trial is concerned. Now, we also must note that the right to a fair trial is one of those non-derogable rights. Non-derogable in the sense that it's an absolute right. You can never subject someone to or deny someone a fair trial under any circumstances. So a fair trial is one of those rights they're about for under Article 44 of the Constitution, which is a non-derogable right. Now, when it comes to torture, of course, we also have Article 24, still in the Bill of Rights, which states that no person or citizen shall be subjected to any form of torture. And also torture is provided for under, freedom from torture is provided for under Article 44, the same category of non-derogable rights. So the non-derogable rights are those rights that you cannot, under any circumstances, restrict. So you cannot say, because someone was caught in this act of violence, he should be subjected to this kind of torture so that we can get any information from him or inform us of any other persons who are involved in that act. So it's a non-derogable right. So the Constitution is very clear, and it declares freedom from torture as a non-derogable right, meaning that it's an absolute right, and under no circumstances can you subject it to any restriction. Of course, beyond that one, we also have other articles like 50, which talks about the enforcement of rights and freedoms. And we have the other legislation that are in place as a result of these constitutional provisions. For example, we have what we call the Prevention and Prohibition of the Torture Act of 2012, and which really is a unique law in a sense that, one, it holds individuals, private individuals. The international instruments that defines torture looks at torture as something that can only be committed by an official person. An official person, in other words, you must be an agent of the state. But our laws, our domestic law, or municipal law, goes broader to say that a person, and a private person or individual can also subject another person to torture, and therefore will be held, can be held personally liable. Before, people used to think that because I'm an officer, I'm a law enforcement officer, if I commit torture, I'm not responsible. It's the agency, whether the agency would be police or prisons or the military, therefore the Attorney General will be responsible. But right now, our laws say, no, that person shall be held personally liable. Then Article 24, of course, also gives effect to another law called the Human Rights Enforcement Act, the Human Rights Enforcement Act of 2019, which you can also have private prosecution. So the Constitution itself, the constitutional provisions have given birth to other laws that are meant to enforce these constitutional provisions that we find quite strong in terms of dealing with those human rights issues. Of course, we have also other institutions like the courts, where if you think your rights have been violated or abused, you can seek redress. And of course, we have the National Human Rights Institution, the Uganda Human Rights Institution. So broadly speaking, we can say we have quite a robust legal regime to deal with torture. However, in spite of having all these provisions within the Constitution, we still have challenges. And that's where one would say, actually, we do not have enough constitutional provisions in terms of operationalizing those. For example, we still have the judiciary still grappling with issues of adequate judges, adequate magistrates, the numbers, and therefore we still have backlog cases. We still have issues of congestion in detention places as a result of cases taking long to be heard. Two, the other institution where we should be seeking redress in case you have been subjected to torture beyond the courts is the National Human Rights Institution. Now, whereas the law is very clear on how this institution should be operating in terms of dealing with these human rights issues, we have a problem. It's currently non-functional because it does not have a substantive chairperson. And therefore, it cannot act or use its powers to release a person who is even illegally detained or who has been subjected to torture, and whereas it has powers to make an order to have that person released, currently it can't do so. Why can't it do so? Is because it does not have a substantive chair. So any order coming from the commission can be challenged and say, there is nothing like a commission today, because for a commission to exist, it must have a substantive chair. Three, it cannot sit as a quasi-judicial body to handle human rights violations such as torture, such as the lack of, because for it to constitute itself into a quasi, as the law established, it must have a substantive chair. Three, it cannot subpoena anyone. Right now, the commission as it is, it cannot order anyone to appear before it because it does not exist in law. The absence of a lack of a chair, the absence of a substantive chairperson means it has no powers to order someone to appear before it and show cause why he or she should not be punished for violating any rights. Two, or last but not least, is that it cannot issue any report regarding the status of fundamental rights and freedoms in this country. Therefore, the institution as it is right now is redundant. We have a constitutional provision that says there shall be a commission with a chairperson. But now we have a commission that has no chairperson. And yet the law is very clear and mandatory that that commission must have a chairperson. So it's a redundant institution and therefore goes against those constitutional provisions that would interpret as being enough to deal with issues of torture. So in conclusion, one of my, what I perceive as one of the biggest challenges in as far as reinforcing these constitutional provisions is the fact that when this constitution was operationalized in 1995, the country did not take time to carry out enough civic education to educate the citizen on what does it mean to have a constitution and what is the effect of these constitutional provisions in terms of enjoying your fundamental rights and freedoms, in terms of promoting democracy, in terms of ensuring that people understand why we have certain institutions so that they can respect them and understand their mandate. We only refer to constitutions when we are going into political questions like elections, when we are going to know when citizens challenge certain acts, when they say, but it's not something well ingrained into the citizen to understand and appreciate that we have a constitution, because we have many citizens who are non-state actors who continue to see torture as something very normal, because torture is not being carried out by only law enforcement, even private citizens. When you go downtown Chiseka and you meet someone who has been arrested or accused of having stolen a spare part or something, the kind of torture is subjected to. Children in homes are still being subjected to torture by their own parents over small things like money, over small things like food. So torture is still rampant. It's not only within the state actors, it's also amongst non-state actors, our own civilians. In schools, corporal punishments, in spite of being banned, is still being practiced. We've heard of incidences where teachers have beaten children to death as a result of punishment. So that is my submission for now, Mr. Masesa Demiano.
Thank you very much, Bob. That is quite a mouthful, and you've really dissected this for us. I just want to also bring in Sarah and just ask a little on this same area. Are these safeguards enough? Do we what we call enough? Are they enough?
Well, the law, the prevalent law is sufficient. In addition to the local, to the constitutional provisions, as well as provisions in the Acts of Parliament, as highlighted by Bob, we have international instruments like the Universal Declaration on Human Rights. It prohibits torture in its Article 5. We have the International Convention on Civil and Political Rights. It prohibits torture and inhuman treatment in Article 7. We have the African Charter on Human and People's Rights. It also prohibits torture. Majority of the torture we are witnessing in public is by security agencies, and our Article 221 of the Constitution is very clear on, directing all security organs to observe human rights. That's in addition to Article 22 of the Constitution, whereby all organs and agencies of the state are mandated to protect and preserve human rights. So I don't think we have any gaps in the law, as is Damien. But we need to know that constitutionalism goes beyond paper provisions. Once you don't have the spirit of the Constitution or the practice by the main actors in a country, then safeguards cannot be enough. That's why we have gaps like absence of a functional Human Rights Commission. If our country and leadership were committed to the protection and observance of human rights, a country would not spend 2 years or more without a chairperson of the Human Rights Commission. That shows the lack of political commitment to the protection and observation of human rights in this country. And I wish to use this platform to call upon President Museveni that yes, there are gross human rights violations by duty bearers in this country, people mandated to protect the people, take on the people and torture them with the kidnaps, with the assault, with extreme bodily harm, with inhuman treatment. But the president has just taken a new oath to protect and preserve the Constitution. The fundamental provisions of our Constitution is Chapter 4 of the Constitution on Fundamental Human Rights and Freedoms. So if the president is committed to his oath, let him appoint the chairperson of Uganda Human Rights Commission, because this country is not lacking people qualified to occupy that office. Beyond that, Damien, we have had court decisions denouncing the acts made of security agencies on torture. And I wish to highlight the key decision by the Constitutional Court arising from the attack on the Temple of Justice by the Black Mamba raid on High Court during the time of trial of Kizza Besigye and others over charges of treason and misprision of treason. And in that case of Kizza Besigye and others versus Attorney General, the court was on record, or the Constitutional Court. It said that mistreatment of suspects warranted the discharge or acquittal of those suspects. It even went ahead to say that such a trial that is crowded by abuse of process would mean that no fair trial would result. And we know that Article 28 provides for a right to a fair trial for every person suspected to have committed a crime. So once you violate the due process that leads to a fair trial, nobody can guarantee that there would be a fair trial, and that trial is declared a nullity already by the Constitutional Court. We have seen suspects paraded. There has been subsequent rulings since 2007 by the Constitutional Court. But unfortunately, we have seen suspects paraded in court after being tortured. One such decision taken by court during the Arua violence in the Arua by-election in 2019, I think 2018, Arua by-elections. The Chief Justice then, Justice Bat Katureve, took a decision and directed courts not to try any suspect that is presented after torture. People had been presented in court, breeding, including women, breeding before court, and the magistrates then had gone to read charges to tortured suspects. And the Chief Justice ruled that practice and said, whenever suspects are presented in court, and there is also secretaries. But we saw recently, I think last week, suspects paraded in Nakawa court in the case of attempted assassination of General Katumba Wamala and the murder of 2 others, including his daughter, with fresh torture marks. And the magistrate went ahead, to preside over a fraudulent trial of the same, reading charges to tortured suspects, and it is a practice of our security agencies, unfortunately, that they are in the habit of forcing suspects to sign self-implicating statements after torture. And these statements are a narrative.
Apologies, Elison here. I'm sorry.
Even where they parade suspects before media and claim that they have confessed after torture, it is yet to be seen whether those confessions can stand a day in court, because they have always been outlawed as statements obtained, people torturing suspects sign self-implicating statements. And then you see the police and other security agencies deliberating on how they have made head in obtaining confessions from hardcore criminals. So we have these practices that have been entrenched over time. The security agencies seem to have total disregard for preventing their appetite against torture, against inhumane treatment of people suspected to have committed a crime. And it is a shame on our part as a country. I submit.
Thank you very much, Sarah. You've taken that through. I just realized that Elison joined on, but while joining on, because we shared the link with like the way Master did, so it is showing my name. So it is Elison trying. So I would request that Elison, you try to rename your gadget from my name to yours. So try to rename that, and your apology for late coming is accepted while you rename.
How do I rename?
I'll request the host to help us do that. I'm sure he will be able. Yes, it is now renamed. That is good. Yes. Right on there. I'll not give you the opportunity to rest. You joined in late, but I'll not give you the opportunity to rest. I just want to start shooting you right away. Are you with us, Elison?
Yes, I am.
Yes, Elison, maybe for our viewers, Elison is a partner at Kampala Associated Advocates and a lawyer. He's one of the senior lawyers around town. So I would want to start with you, Elison, again. This is where we were. I just want to bring you up to speed, and I want you to help us engage on this one. What are the constitutional safeguards against unfair trials, torture, and inhuman treatment for the protection of the dignity of Ugandans? What are those safeguards that are available?
Is Elson on the call?
Yeah, he's back. I think it's back.
He's in mute.
Try to unmute. Yes.
Can you hear me?
Yes, we can hear you now.
The Constitution prohibits torture, and that is the biggest safeguard. Torture is unconstitutional and it is illegal. There is also a law, the Prevention and Prohibition of Torture Act. So a citizen should not be tortured by any person or authority, and the right not to be subjected to inhuman, degrading treatment or punishment is a non-derogable constitutional right. That means it is one of those rights that is absolute and cannot be suspended, along with, I believe, 3 other rights that are in Article 44 of our Constitution. So that is the constitutional position.
To what extent are these safeguards implemented in Uganda?
I am not getting your question. What do you mean by implement? So you shouldn't be tortured. If you are tortured, it's illegal. For example, you have a right to your property, so you shouldn't be robbed. If somebody comes and robs you, it's illegal. But can I say to what extent is the robbery stopped in Uganda? I don't know. It happens in Uganda and elsewhere, but it's illegal.
Interesting. So, thank you, Elson. You said the conversation. I know you will have a lot to respond to. I want to invite us on this session, yeah, and also from where we started. I want you to just tell us to what extent are these safeguards implemented in Uganda as they are provided in the Constitution and all other provisions.
Or were you asking me? Sorry, I didn't hear that.
No, bring you Mase, yes, Mase Munduru, yes.
Thank you very much, Demian. I hope you can still hear me.
Yes, we can, yes.
Great. So I think in terms of the extent to which these provisions are applicable, Sarah did hint on some examples that we've seen over the past couple of years, including just last week, where suspects were paraded with clear evidence of torture. Actually, if you look at those videos, the evidence of torture is very fresh, meaning that this has just happened. And I believe this is not the first one. We know that during the electoral period, there were a lot of complaints with regards to suspects being tortured by various security agencies. We have had for a long time debates on the existence of safe houses. It's been a cat and mouse debate where the security agencies many times have run away from admitting that there are safe houses that exist in this country as torture chambers. And so for me, yes, we have robust laws and we have them as the previous speakers have properly articulated them. But when it comes to implementation, we have a huge gap, specifically when it comes to holding security agencies or members of the armed forces accountable for torture. So earlier on we spoke about the Human Rights Act and the anti-torture and all of that, but you can hardly present evidence of any conclusive trial of any member of the security agencies that has been accused of torturing a suspect in custody, even when there is clear evidence of such torture. And that, for me, speaks to the growing impunity in our country, especially when the torture relates to a suspect in custody for whatever reason. The law lays down very clear procedures about how to handle a criminal investigation process. But we are also aware, and if you look at reports that have been done by credible institutions like the Human Rights Watch, that does, documentation of human rights violations all across the world, when they were writing about Uganda, there was chilling evidence and confessions from very many suspects who were kept incommunicado, who underwent very brutal forms of torture. They were beaten, they were kicked. Others, suffered dislocations as a result of the kind of objects that were used as an instrument of torture while in custody. But even with all of this, we have not seen a clear pronouncement of the security agencies or their commitment towards ensuring that torture of suspects does not in any way form a major part of a criminal investigations process. In very many countries, I know that security agencies have no tolerance policies when it comes to issues of torture, because one, most of the countries, just like Uganda, are also signatories to international treaties. And if you look at Article 7 of the Rome Statute, you realize that torture and the forms of torture that we shared earlier on, that whose examples Sarah rightfully put, are considered as crimes against humanity. That is how serious it is. But in our case, we are yet to see the commitment of enforcement agencies towards, holding those who have been perpetrators of torture accountable. We also see that there is an overlap of duties between the different security agencies. We have so many security agencies in existence apart from the Uganda Police. We know that there are so many instances where there are joint operations between Uganda Police and the UPDF. We also know that there are other sister agencies like the CMI and others who are mandated to investigate or conduct arrests in certain specialized circumstances. And all of these layers of security agencies, some without very clear roles, further deepen the whole element of torture in our criminal system. And as a result, it becomes very difficult allegations of torture. You will find a suspect who is complaining of torture, and police will really come out to deny, and we've seen that on national TV, that they're in possession of such a person. They will deny knowledge of such a person, or even the torture that the security agencies are being accused of. Many times, most of these arrests are done arbitrarily, and also they are done in a way that you cannot easily identify the perpetrators of such human rights violations. And now the fact that we do not even have the Human Rights Commission function makes it even worse, because that means that there's no accountability for torture, and in any case, there's not been a conclusive report from security agencies on an investigation into a torture allegation. So for me, I think, there is a very huge gap between us having provisions within our legal framework on torture and inhumane and degrading treatment, but when it comes to the implementation, it is not possible. The other angle has also been the whole issue of forced confessions. If you look at several videos that have made rounds, especially on the internet, from some former suspects, you realize that the admissibility to crimes has been obtained under very extremely traumatizing circumstances. They have complained about, extreme torture and being forced to admit to the crimes that they're being accused of. And yet we very well know that Section 25 of the Evidence Act, it prohibits, first of all, and also prohibits the use and admissibility of evidence that is, obtained under such circumstances. I'm really looking forward to that day that the security agencies can put into consideration, the layers of complaints that have been raised, both by the international community through reports, but also locally through our local media that have had the opportunity to, research in this area, I wish they could take the recommendations and also the evidence that has been presented to hold officers accountable, so that we demonstrate our commitment to our constitution. We demonstrate our commitment to all of the laws that we ourselves have passed through our own parliaments, that we shall uphold rights, that we shall uphold especially the right to fair trial, and also protect the rights of suspects, because they're innocent until proven guilty. But our practice does not even demonstrate that. Basically, the way suspects are treated does not point to, the presumption of innocence. It really presents them as guilty. And then the fact that the court, even when these suspects are paraded, does not try to take steps to ensure that, charges are not read to a tortured suspect, for me, speaks a lot to our commitment as a country when it comes to observance of human rights.
Thank you very much, Masi, for breaking that down for us. I think now I can again bring on Elison. You sounded convinced that true, there are provisions in the constitution, and of course torture is non-constitutional. But then I would want to ask you a quick one on this one again. Why has torture persisted as a method of obtaining confessions from suspects by police and their sister agencies? I want you to just tell us, because these are some of the things that we are seeing. And this spans from way back from about 2001, political prisoners. Then now we have even, this was associated with high-end crimes. So why is torture a tool for this? Yet it's unconstitutional.
Sorry, I was on mute. Torture is illegal. Yes. Torture is unconstitutional. Yes. And yes, torture is used a lot. I wouldn't say a lot. I don't have proper statistics. Yes, torture is used by security agencies, or has been said to be used by security agencies in the conduct of investigations. Of course, it's partly a cultural problem. I think in our traditional society, someone once said that even our own sayings of, a dog that steals pays with its back. So yes, there's that problem. Secondly, some people use it as a method of extracting information. That is also a very primitive method of extracting information, because that information so extracted is not admissible. And even from our traditional societies, that thinking is certainly not consistent with modern theoretical and ideological concepts, and with the world as it has moved. I think a discussion on torture versus no torture is there's certainly no proponent or no right thinking member of society can find themselves being a proponent of wrong methods. And I agree that in the pursuit of justice, the security sector should ensure that the means they use are as pure as the ends they seek. Because it is possible that someone picks up a suspect. I'll give you an example, which used to appear in many blogs abroad. You remember in 2013, the United States military was accused of torturing Khalid Sheikh Mohammed and a number of people for the crimes of bombing Americans on the 11th of September. And when they were arrested and taken to both in Abu Ghraib in Iraq, Bagram Air Base in Afghanistan, and subsequently to Guantanamo Bay in Cuba, they were tortured. In fact, the United States government sought a legal opinion to say that some forms of beating do not constitute torture. And some forms, for example, if they put your head underwater for a period of time and brought it up to suffocate you, they got a legal opinion from some lawyers saying that that sort of thing, they called it waterboarding, and they said waterboarding was not necessarily illegal, it did not constitute torture. And the argument at the time was, what happens if you have Khalid Sheikh Mohammed locked up in your cell you are aware from your information that there's about to be a terrorist bombing of another building in New York, do you subject Khalid Sheikh Mohammed to his constitutional rights, or do you try and give him an incentive to talk? That was the argument at the time. I think that the same challenge can easily be faced by other security agencies in countries like Uganda. Sometimes people do use that sort of method to extract information to either avert or prevent further attacks. But what I accept is that it is a primitive method. What I don't accept with the premise of your question is, why is it prevalent in Uganda? I think it's prevalent everywhere in a way. And I think that that for me is the proper context. So why they use it, how it's used, who uses it, I think we all agree. And the constitutional premise in Article 24, I believe it is the correct premise for us to start from, that it is illegal and that it is wrong. Where I am a bit of another view with Mercy is when she says that we shouldn't allow prosecutions. I think it's touch and go. The courts have very strongly, in some cases and correctly in my view, discontinued trials where the prosecutorial system is abusive of rights and of the law generally. But I would suggest that having a blanket concept of saying if you are tortured, you cannot be convicted. I mean, I am aware of a case where someone came to someone's home and killed people there and was arrested. I think if you tell the victims of that crime that some policeman slapped him inside the cell and now boxed him in the chest, and because of that he is free, you may be promoting more anarchy than you can hold. So I think it has to be a fine, logical, case-by-case balance.
Thank you very much, Elison, for that. I think then I would want to invite in Jude. Jude has joined us. Jude is the managing partner of Jude Byamukama and Kampala Advocates. Jude, you've been away. I suspect you sent in your apology, and I say yes, apology granted. But then I would want to invite you on here and you share your thoughts on what exactly that Elison has just been responding to. You need to unmute. Try to unmute. Yes.
Thank you, Damien. I think the main issue that we have with torture is the biggest concern that we have in Uganda is first of all, it's not the law. The constitution is quite clear. There's a prohibition against torture in the constitution. We have got an Anti-Torture Act, which specifically says evidence obtained through use of torture shall not be used in courts of law. And to crown it all, we even have the Enforcement of Human Rights Act 2019, which specifically provides that where an accused person who is pending a criminal trial can prove that they were tortured, then the trial is a nullity and must be stopped. In fact, I've tried to test this provision and not very successfully yet. The court's kind of using a high standard to prove whether torture occurred. But I think it's a public secret that torture of suspects takes place. Some individuals have this view that, sometimes it's necessary because you need to extract information. But the truth of the matter is the majority of torture doesn't take place because maybe he wants to prevent a crime that may happen. It's usually about forcing somebody to confess to something they did or they didn't do. I'll give you a quick story. Some 2-3 years ago, I represented an accused person who was charged with attempted murder. And after interviewing her and no, not attempted murder, but as an accessory to murder, because a murder had happened. This person had spent over 1.5 years in prison. And the director of public prosecutions was waiving a plea bargain agreement. A plea bargain agreement is basically an agreement where the state says, let's agree on the punishment you should serve, provided you accept that you committed this offense. My client was offered a plea bargain. I was opposed to the idea because I was very sure she was innocent, but she was in prison. She had spent there 1.5 years, and the state offered her unconditional release. They simply told her, accept you committed this offense, let the court convict you and sentence you to the time you have already served in prison. What did my client choose to do? She took the option. Why? Because she was in prison. And you know, being in prison is also it can be a very traumatic experience, especially when you are in prison on remand pending trial. And if you are convinced you are innocent, but you are on remand and you don't have bail. She simply wanted to get out of prison, and I could understand. And eventually, and indeed, she got out. Now, that's the same thing that usually happens with a lot of torture cases. A person who is innocent, if they are subjected to torture, they are going to many times accept what they didn't do. There may be a few cases where a person who is tortured maybe committed the offense and then maybe ends up giving leads to law enforcement, whether to security or to the state, to be able to identify more suspects. That can happen, there's no doubt. It may also happen. But the majority of cases, you get people who clearly may even have no idea about whose nexus to an offense is very, very poor. And then because they know because they have either been tortured or they are scared of torture, they agree to things that they know to be false. And for me, that is the biggest risk that we have to avoid. I know there is a time when President Museveni, I think, wrote a letter which was published in the media a few years ago, some 2-3 years ago, where he was specifically discouraging torture for that very reason, where he was explaining that torture may make innocent people admit what they didn't do. And secondly, there are alternatives. We have got advanced technology now, which should enable us to be able to figure out who has committed an offense and who hasn't. So if what I think is lacking and that continues to result into these prevalent cases of torture is a respect for rights of detainees, respect for rights of people who are either detained in police custody or who are in prison, have got certain rights. And unfortunately, it appears to me that within the law enforcement, within the police, within the intelligence circles, there is absolutely no appreciation. There is very little regard or appreciation for the rights of suspects, especially their rights to human dignity. To know these are people who, even though they are suspected of having committed serious offenses, they have a right to be treated with dignity. That has always been lacking, and it takes a bit of effort for our intelligence circles, our law enforcement, for the people who run police stations, for the prisons authorities, for them to appreciate and realize they need to treat suspects and prisoners with dignity. It's where the problem is, in my view. And we may occasionally have a few cases which seem to be politically motivated as well, and that can also be a cause of concern. But the general culture appears to be of disregard for rights of suspects. And that's where we need to focus our attention. There is not, when a crime is committed, some people are going to be suspects. And occasionally you are going to have many people who are innocent, but who maybe are in the wrong place at the wrong time. And so they end up being suspects. That can happen. That's why it's critical that we make sure people are treated with dignity. Even if the courts of law decide that this person is guilty, the person will go and serve their sentence, whatever it is. And but if a person has been tortured and has been subjected to such a traumatic experience, and the courts of law decide that this person is innocent, what gives? Who is going to be held responsible for that torture? Nobody is likely to. I think maybe what needs to be done in all these cases of torture, first of all, every time I come across suspects who are alleging torture, I tell their lawyers to take advantage of the existing legal framework and take legal steps. We have got the Enforcement of Human Rights Act 2019. Like I have indicated, it specifically provides that if a person has been tortured, then their criminal trial is a nullity. I would like to see many more people trying to take advantage of the provisions of that law for whatever it is worth, so that we can send a clearer message and sensitize law enforcement, sensitize the police, sensitize military intelligence that torture is not a useful idea.
Thank you very much, Jude, on that one. And I think you've really brought it. You've given us the other perspective that I would want also to invite in Robert. Robert, from picking from what Elison said, is like it depends on who is possibly the complainant. If your relative has been possibly you're the one complaining over the person being possibly murdered, I would want to say, and there's need to get that information. It seems to agree that there has to be some level of torture that needs to be used.
Are you quoting me correctly?
I want to bring in Robert in that context.
Yeah, but with proper context, I didn't say that. I said that if you say that every form of torture leads to an immediate acquittal, then victims of crime may become a problem. If, for example, someone was arrested for attacking your home and he is acquitted because a policeman has boxed him, well, don't you think that in the long run, you can end up creating a different problem? That's what I said. I did not say that if someone has attacked your home, he should be tortured.
Interesting. Okay, Robert, what do you have to say about this?
Thank you, and I would like to thank my colleagues Jude and Elison for their submissions. They're good. I think one point we need to emphasize is the practical aspect, what we see in our society. As I indicated earlier in my submissions, I told you that torture is not only actually being carried out by state actors. There are more cases also by non-state actors. And I told you that Uganda has advanced itself in terms of jurisprudence. We are the country that redefined what torture is. The international instrument was so restrictive on what constitutes torture. The International Covenant on the Prevention on Torture states that torture could only be carried out by someone in his or her official capacity, meaning that private actors could not. But in a famous case, whose citation is the Uganda Human Rights Commission 264 of 1999, Fred Tumuramye versus Gerard Bireete and others, Commissioner Liro Mara, as he was then, came out and defined torture under international law as being too restrictive to indicate that torture can only be carried out by official persons, and said even private individuals. This was a case where Fred Tumuramye had been apprehended by the village chiefs and neighbors that he had been suspected of having stolen a cow, and they subjected him to severe torture. So his defense was trying to argue that, look, under their law, under international law, torture can only be conducted, can be only carried out by official persons. And Ali Romara disagreed and said, no, private individuals. And if you look at our law on the prevention and prohibition of torture, it also holds private individuals as personally liable. So I wanted to emphasize this, that we've gone ahead, but torture still prevails in our societies. You still see, I tell you that in downtown, if you are suspected of having stolen something, the kind of treatment you'll be subjected to really amounts to torture. Now, in the cases where my friend talked about where they could make use of the law in terms of the Human Rights Enforcement Act, the challenge, the practical challenge we are facing here is when people try to take private prosecutions to ensure that they can, then the DPP takes over. Then you see a trial not really taking place. You see a trial just being delayed, and you eventually forget about it. So it goes back to what Sarah Bireete was talking about. Do we see goodwill from the side of the law enforcement, from the side of those who control the instruments of coercion, the state? Do you see a will by the state to ensure that torture is totally eradicated or even reduced to numbers where they are manageable? So it is important that really we interrogate these. What's the practical aspect? Do you see the law enforcement really claims? I mean, the fact that they can parade suspects before a court of law with all those marks, and they do not shy away from even covering, and they let the whole public and the media see this, is an indication that really there's something wrong. From where they were coming from in the areas of custody, whether they're in the police cells, whether they're in other detention centers of sister agencies in Kirenga or Mbuya, you should be seeing someone take responsibility and say, we need to arrest or to prosecute whoever was holding. As human rights defenders, we are not saying that when someone is tortured, that an acquittal takes place. No, we want to see the trial regarding the rights, the fundamental rights of this suspect take precedence over this other charge that you are presenting for, so that first of all, he's treated, and two, the persons who are responsible for torturing him or her are prosecuted, and then the other trial can go on where he's being suspected of having committed an offense. So for me, the challenge I'm seeing is the lack of real political will, especially from the state. You see, Demiano, the state has all the instruments of coercion under its control. It can make you do what you would otherwise not have wanted to do. So we want to see the state machinery come out and say, we are going to punish any individual who was involved in these acts of torture, to show commitment. But as we have always said, we have the very good laws, we have very good policies, but when it comes to implementation, we have a very big challenge there. And by the way, we need also to note that the treatment of torture victims is quite a huge amount of money. And me and you as taxpayers should be very concerned, because if you look at the backlog the Solicitor General has in the Attorney General's office, in terms of awards that they're supposed to be paying victims of this kind of human rights violation, is quite an amount. And this is taxpayers' money. What me and you contribute to a public purse is going to be used to compensate this. Now, we've changed the law to show that we will no longer hold the Attorney General liable, vicariously liable. We are going to hold individuals personally liable. But this is not being done, so that somebody's house is either auctioned or sold so that he can compensate. When that pain starts, when they start enforcing such things, that's when you see people refraining. But I must also emphasize that we should not look at torture being carried out by only state actors. Non-state actors continue to also subject fellow citizens to torture. Thank you very much.
Thank you very much, Robert, for that. Sarah, I know you would want to have something to say on this, but I also want to ask you, why do we still have practices like kidnaps and detention without trial, or also safeguards, which are not safeguards in the Constitution and other related laws, notwithstanding?
Well, Demian, the cause of torture, kidnaps, illegal detentions, or detention without trial really is growing impunity by NRM government. If you look at the first years of the 1995 Constitution, 1995 to 2005, there was, to a big extent, observance of the Constitution. But as we degenerated on the governance front, we also degenerated on all other tenets of governance, including protection of human rights in this country. So you have security chiefs in this country that conduct themselves as warlords. If you look at the manner in which General Okech, the deputy IGP, has been, he could have done a good job. You know, people are tired of high-profile matters with no accountability, with no questions as to who is responsible, and citizens want answers. But to what extent do you abuse the due process for you to obtain the so-called answers? And is it happening for the first time? Previously, we have seen, you know, General Okech is behaving more like General Kihura. General Kihura would parade suspects as if it's a concluded case, as if he has obtained conviction, you know, guilty until proven otherwise. And most of them would be, you know, tortured. In the case of murder of Muslims, and General Okech is repeating the same things that General Kihura would do in the way he would conduct investigations, do media briefings, parade people, which is also a violation of their, you know, of their right to a fair trial and the presumption of innocence. Yes, we want answers, but, you know, I don't know whether security forces, we know that the Human Rights Enforcement Act makes personal liability for the people who conduct themselves contrary to the laws. But when you file, I remember during the last concluded elections, we tried to do public interest litigation around police and army chiefs that were at the front line of abusing laws of the land. But people who would be witnesses in the case, the question they would ask is how sure are they that the drones would not pick them in the night immediately after filing of cases. So you have this fear that is gripping the population and cannot enable even public interest lawyers to seek justice. And this will, you know, will increase the level of impunity. As a country, we have reached an extent of attracting international sanctions. If anybody had said that President Museveni, under his leadership, Uganda would attract international sanctions because of failure of governance under his regime, people would have assumed that you are mad. But we have deteriorated to the level of international sanctions in regard to abuse of human rights, in regard to growing impunity, in regard to untouchables, people who walk around Kampala streets displacing people in the trenches on the roads as if they are warlords in this town. And it is going to get worse. You know, there's an African saying that it gets darker before dawn. I think it will get worse before we can salvage this country in terms of fighting impunity. I don't know how deep it will go. People have been celebrating as these suspects in Katumba case are paraded. I don't know how many people were tortured for the murder of the late Kawesi. Several people were tortured, including the mayor of Fort Portal. But what did we achieve in terms of conviction and curbing the crime of high-profile murders? I think we didn't achieve anything. And why can't police do professional investigations without torturing suspects? Is it possible? Do they have such trainings? Do they have such capacity? Or do we have people to call, to write home about as professional investigators in the police? I think these are the questions that we should interrogate. If we celebrate as a country, we celebrate tortured suspects. The police has made progress. What progress? What if they are wrong and these people are not the ones who did the crimes? Even if they did the crimes, are they taking the law in their hands by torturing them? Then how different are they? So should our police then qualify to be called the mob? I think these are the questions of the day, Damien.
Thank you very much, Sarah, on this one. I know, Elson, you're provoked to say something, but I want to bring in Masesa. Elson, we had this conversation yesterday, and you wanted to. Can I give you an opportunity to say something on this?
You conduct how you want. Of course, you have to congratulate Sarah for politicizing the discussion.
Let me bring on Masesa. Masesa, recently the Constitutional Court outlawed a trial of civilians in the court martial. What does this mean for the right to a fair trial for Ugandans?
I think that was a very progressive decision, in my opinion, because also part of why we're still sitting here talking about this. Elson can, of course, say it's politicized, but I mean, you can hardly separate Uganda from politics. So we cannot talk about issues of justice without having a 360 degree of political issues, because a lot of the cases where torture has been evident also have to do with, politically motivated crime. So I just have to first emphasize the fact that part of the problem that we've had is the militarization of, the country, basically. So you'll find that even in law enforcement now, there are so many situations where there are joint operations between the police and the army. And in these circumstances, when the civilians find themselves on the wrong side of what they perceive as law in that moment, many times they end up in military detentions. They are produced in military courts, and the way the proceedings happen at the military courts vis-a-vis the circumstances under which the suspects were arrested has a very huge dimension and also implication in terms of respect for the rights of a fair hearing, but also broadly just the rights of the Ugandans who find themselves in a situation like this. So first, I was very happy that the court pronounced itself on that matter, and what is left to be seen is Uganda's commitment to ensuring that we actually respect the pronouncement of the courts, especially when it comes to having civilians tried in military courts. I think there has to be a clear-cut difference between crimes that are triable in the military courts and those in the civilian courts. And unfortunately, where we are today, it's very hard to make a distinction between the different security agencies. Sometimes certain actions that should purely be within the mandate of the police are executed by the military. So many times, basic operations, even what happened at the end of last year, where we lost so many Ugandans during the November protests, was a joint operation between the military and the police. And if you look at the documentary that BBC did, the police was distancing itself from the operations, yet the vehicle that was being used to drive around Kampala Road was a police vehicle. So in circumstances like this, when citizens get caught up, there's an interplay between the two agencies, and as a result, the roadmap to justice is wavered. So you find that a citizen will end up in a military detention facility for a crime that could be triable in a civil court. Many times, however, even when these arrests are made, suspects do not have access to lawyers. The 48-hour rule is not respected. Of course, that against also allegations of torture and all of that. So the court pronouncing itself on this matter, we needed it like yesterday, especially where Uganda is in terms of our political landscape, where there are very sharp divisions based on political affiliations, we have so many inequalities along ethnic lines and all other, spheres of life. It is very important that, we pronounce ourselves clearly with regards to issues of social justice, because that touches the heart of our politics. So, Demian, I must say that for me, that was a welcome ruling, and I'm waiting to see how this is respected and also how that is enforced, especially by our law enforcement agencies in their various capacities.
Thank you very much, Masi, on that one. Jude, to you, do you think what does this mean for the right to fair hearing, fair trial in Uganda, the Constitutional Court pronouncement on the court martial?
Yes, you can hear me?
Yes, I can. Yeah, we can hear you. Yes.
Yeah. First of all, maybe I'll begin with a bit of a disclaimer that judgment is not final. It appears the Attorney General has chosen to appeal that judgment, to my disappointment. So that means we shall probably have to wait for, I don't know whether for a year, 2 years, or 3 years, or 5 years, to know what the Supreme Court is going to decide about that particular judgment. I think it's a judgment that should not have been necessary. There were so many leads. This is the third time that the Constitutional Court is pronouncing itself on the legality of trials of civilians in the court martial. What was different this time is that the Constitutional Court mainly pointed out something which should be very obvious. That's why I think even though the decision is a 3-2, it seems to me that the Attorney General has various modes of dealing with this judgment as opposed to appealing. They could, for example, choose to change the law. The Constitutional Court simply pointed out what for me is a very fundamental point, that the court martial cannot be trusted to be an impartial and independent court, not because of political reasons or what we know or its behavior, but because of the way it is designed and set up in the law. First of all judges, all judicial officers, anybody who administers a court in this country takes a judicial oath. That judicial oath confirms that that whoever is appointed a magistrate or judge or justice of the appellate courts will administer justice without fear or favor, and without favor, really without and with no ill will. Members of the court martial don't take such an oath. Instead, they take an oath to basically serve the commander-in-chief, which for me is a huge problem. And it's an indicator that the court martial clearly was set up to aid military discipline in the army. And smuggling in civilians, and they start charging civilians with murder. I have a civilian who was charged for murder in the court martial and sentenced to 30 years imprisonment. And it's very funny when you look at the proceedings, it's a huge problem. The court martial, with due respect, may be very knowledgeable in matters of military discipline. But when it comes to matters of criminal law, administering criminal law, when it comes to the criminal justice system, the court martial is not equipped in any way to administer criminal justice. So it seems obvious to me that the long-term solution to this is, if they want the court martial to continue trying civilians, then the court martial should be presided over by judges who are appointed like any other judges and who are not mere deployments in the army. But since that cannot happen because the court martial is not set up to do that, they need to keep civilians out of it. And it seems to me a very obvious point. Even the two judges who disagreed with the majority, by the way, their approach was one of them was of the view that the Supreme Court pronounced itself on this issue already, and they chose the parallel position. which I think was a bit of error on the part of that judge, because this case was a bit, the facts were a bit different. So while this decision of the Constitutional Court lasts, I think it's a good one. I'm fairly conflicted. I was hoping I can begin ensuring some of my clients benefit from this decision until I learned the sad news of the Attorney General's intended appeal to the Supreme Court. But hopefully it also sends a lesson to many of us who are caught up in the criminal justice system, whether as lawyers, as suspects, as accused persons, as civil society players. We need to keep pushing the envelope. We need to continue challenging some of these issues before the courts of law. We don't have to lose hope in the system and think that the system cannot self-correct. Some of these areas, once in a while, it's possible for the courts to deliver decisions that self-correct prevailing practices that violate our constitution. So in that regard, the decision, no matter what happens in the Supreme Court, I think it remains and will always be an important decision. And by the way, the African Commission on Human Rights had already indicated that Uganda should stop trying civilians before military tribunals. The African Commission is a body under the African Union. Uganda is among the countries that is always singing about Pan-Africanism, about political integration, how Africa should unite. If we think Africa should unite, then let's walk to the top. Let's begin by listening to the bodies that have been set up by the AU. That should not be rocket science for us. Let's not pretend that we are interested in having a united Africa that can hopefully federate into one body. And yet, when organs of the AU give us instructions, we disregard them. I thank you.
Thank you very much, Jude, for that one. And then I would want to invite you, Elison, on this one. Possibly you have your thoughts, but also is the court martial relevant for the trial of hardcore criminals? What implications does it have on the doctrine of separation of powers and the independence of the judiciary? Your thoughts, Elison?
Thank you. Before that, can I say something about the political speech which Sarah made? Can you hear me?
Yes.
So I was asking for your permission to respond to the political speech that Sarah had made. She had made a political speech about the NRM government, the 1995 constitution. So do I respond to that or do I just go straight to what you've asked?
No, let him respond.
Yes, yeah.
Damien, can you hear me?
Yes, I can hear you. Yes.
I take issue with the description of the Deputy Inspector General of Police as a warlord.
Okay.
I think that when we are discussing, we shouldn't necessarily be too harsh. We shouldn't verbally torture those who subject themselves to public service. We should scrutinize them, we should criticize them, but I take very strong exception to calling the Deputy Inspector General of Police a warlord. Also, I do not think that the security forces are as portrayed in this discussion. We must, I began off by giving you the example of people who were responsible for the blowing up of the United States Twin Towers in New York in 2001. One of them is Mr. Khalid Sheikh Mohammed, who was arrested. I do not know, and maybe I can be corrected, if Mr. Khalid Sheikh Mohammed has ever been subjected to a criminal trial in a court of law with proper judicial safeguards. I know, for example, that the United States government set up what you could easily describe as a concentration camp in Guantanamo Bay when they were dealing with the issue of terror suspects. I know, for example, whether you talk about Kenya or Tanzania, the United Kingdom of Great Britain and Northern Ireland after the bombings on the London Underground, I do not know, or I am not fully aware of countries that have been able to conduct public open trials of jihadists. In this country, we have had a conviction of people who were accused of blowing up the football World Cup lovers in July of 2010. The people who you are talking about, court of law, being presented there and produced in the court. So the starting point is if our security officers had been Americans, had been British, had been Kenyan, had been whatever, people like Sarah would probably be watching their movies. I have just watched Narcos on Netflix, where we're looking at American policemen who shot Pablo Escobar. This Ugandan security of warlords, of criminals, of thugs, the sort of description we have made, went with their intelligence, established where Jamil Mukulu was, applied to a court of law in Tanzania to extradite him and brought him back. Their American counterparts shot Osama bin Laden in the middle of his head and threw him in the deep blue sea. I'd take very serious exception at calling the people who go to serve in the security establishment warlords or criminals, or to depict them. Their errors for sure, their mistakes, their lapses, there are things they have done wrong. Even in the July 2010 case, torture was certainly used, at least as found by Justice Owinyidolo, as his lordship, the Chief Justice, then was, and evidence was excluded. I think these actions of these people, bringing people into courts in the end, brings scrutiny to their action and allows judicial oversight of their action. But I think that people who go out of their way to find people who are shooting at others and who are committing massive crime in this town and elsewhere, it does take a lot of sacrifice. They are also public servants. They also make mistakes. They should be held accountable. But I don't think it is fair that somebody who has been, like Lieutenant General Lokech, who has been a leader in the military, who has risked his life in Somalia and elsewhere, I don't think it is fair to just come here and describe him as a warlord. And I would say the same, by the way, for General Kaihura as well, and for many of the people who offer themselves in service, because a lot of what people do to hold the country together is pure service. So that is the first exception which I take. The second exception, of course, is the argument.
Yeah, just 1 minute, Elson, before. I think that my reference to warlords was not specific to General Lokech. It was a general reference to security chiefs who preside over kidnaps and torture. So it is that on General Lokech, I was only referring to the torture of General Katumba, but I did not call General Lokech a warlord. I was referring to security chiefs that use methods like kidnaps and torture. Those are the ones I referred to as.
Okay, but I think the overall point, whether it's referring to General Lokech or to another chief of a security entity, I think the point which I am making, I am insisting on. And I am saying that by comparison to many sister forces around the world, the security establishment, including the Directorate of Public Prosecution, cannot, when you compare them with the challenges they face and challenges other countries face, I don't think they fare as badly as they are being presented. I gave you an example at the beginning, that there are legal opinions in the United States which say that it's okay to torture, provided it's waterboarding and not putting something else in someone's body. I don't think you have a similar opinion from the Directorate of Public Prosecution of Uganda. I don't think they're working under much different circumstances. So yes, so the starting point is the criminalization, the verbal torture of our security establishment. Me, I take issue with it. I completely take issue with it. I do not think it is properly contextualized. I think it is oversimplified. And I think it does not look into the circumstances under which a lot of things happen within those security circles. Now, on the issue of the other issue you asked me was about the general court martial.
The court martial, yes, and its relevancy.
And hardcore criminals. The court martial was never designed to try hardcore criminals. In fact, the main point of Section 119 of the UPDF Act was that a person in possession of military stores or found in possession of arms that are ordinarily the preserve of the Uganda People's Defense Forces should be subject, once you conduct yourself in a military manner with equipment that is ordinarily the preserve of the military, then the logic was that you should be subject to military law. I think at that time, they were looking at the people who had done robberies in Kampala using guns, and also I think some of the combatants who were being captured in battle against the state of Uganda, saying that since you have chosen a military conflict, you should be subject to the laws that govern the military. The idea that a hardcore criminal, so they do not take hardcore criminals to the court martial, and nor was the court martial designed for hardcore criminals. I think the decision of the Constitutional Court is interesting because for sure, Section 119 has been stretched, I think even beyond where the framers of that section imagined the section to be. And I think some people are being charged in the court martial who ordinarily wouldn't have been charged, even if you gave Section 119 its strictest of interpretations. I think the judgment of the Constitutional Court is an interesting judgment, but I do think it requires a second judicial look. First of all, in light of the fact that there was previous Supreme Court decisions on this. But more importantly, I think there are other aspects of that decision. For example, the holding that, not that section, I think 2 of the UPDF Act, defining a service offense to stop the court martial from trying soldiers for offenses that are not in the UPDF Act, I think I'd have serious detriment to the discipline, management, good conduct, and order of the Uganda People's Defense Forces. Or maybe it can't, but that's a subject that requires a second judicial interpretation. I recall, yeah, so that's for the court martial. So I think in principle, civilians should not be subject to military law. And I think that principle ordinarily was not the intended effect of Section 119. It wasn't to make all of us subject to the law of the army, but only those who have brought themselves within the ambit of military law. So it was just trying to expand who has brought himself into the ambit of military law. Yeah, but be that as it may, on the larger concept of fair hearings and fair trials, and I think that the overall principle that the military courts should only be for those who are subject to military law is not something that I think is actually controversial. And I don't think that the intention of the parliament that inserted Section 119 into the UPDF Act was to make it apply. Yes, I think, thank you. I see Sarah is asking me if I take issue with kidnap, torture, and murder suspects, with those who kidnap, torture, and murder.
Yes.
I think when we began this conversation, I made it clear that nobody in his right mind supports murder, torture, and kidnap. And certainly everybody in their right mind condemns it. But I think to suggest that that is the story of the Ugandan security establishment is, I I think is I mean the warlord description is I take issue with it, and I take issue with calling security chiefs warlords. I can take issue with both, and I take issue with both.
Thank you very much, Elison. That is noted. Let me bring you, Robert, on the discussion protection of human rights in Uganda, from your perspective.
Come again,
you might
Damian,
want to respond to a few issues that have been discussed earlier. So,
well, what can I say, Damian? We still have a long way to go as a country, because some of these things, as you indicated, are clearly, if we are to observe the rule of law and also observe our legislation and the international commitments that we accepted to abide by, we still have a lot of things to do. Impunity is still in existence, and I think we need to tackle these things squarely on and engage. Otherwise, why do we have constitutions? Why do we have these laws if we feel they are not necessary in terms of such situations? So one thing, as you had earlier indicated, and you seem to suggest that there are certain circumstances where you need to subject someone to torture. You see, once you start doing that and say, no, these are special, then you contradict the same laws that you put in place. Because we've declared as a country that torture is a non-derogable right. In other words, under no circumstances can you restrict freedom from torture. So my view is that we need to start really tackling these issues and see where do the next generation find this country at. Otherwise, we are going to be asked, what did you do when you saw these things happen? We need to speak out, and we need to hold these leaders accountable. As I earlier indicated, that the only machinery that has the capacity to really curb this is the state. And I tend to tell people that we need to differentiate the state from the government. The two are two different and fine. The state is that class of people that control the instruments of coercion. The state is that institution that would make you do what you would otherwise not have wished to do. So if the state is committed to ensuring that torture is eradicated, we will eradicate torture. But as long as they take it as business as usual, then we'll continue to see these things. Of course, the loved ones, the victims of such an attack on General Katumba, his daughter, his driver, will not appreciate. We say, are you looking at the rights of suspects? What about the victims? But we are saying that the rule of law requires us to observe the laws. So what does the law state? At no way is it indicated that torture at one time can be applied, especially when you have caught the victim red-handed. No, it doesn't provide for that. So if we are to build a society that follows the rule of law, that is going to observe the good tenets of democracy, these are the things that we need to tackle head on so that the future generations can appreciate that something changed in this country.
Thank you very much, Robert. I want to invite on Jude. Your take? Jude, are you here? Can we hear you? Okay, Mase, are you there?
Yes, I am, Demian.
Okay, yeah. Okay. Can you take us through what are the best safeguards for the
Yes,
rule of law and protection of human rights in Uganda?
Yeah, I think, in my opinion, first of all, is the political will. We must be willing to acknowledge that we have the responsibility to uphold human rights and also safeguard the rights of all Ugandans, regardless of if they are suspected of a crime or not, regardless of if they are of a different political affiliation, regardless of the kind of crime that they've committed. I think acknowledging and having the will to end it is a very important step. I believe issues of accountability and ending impunity really start from cleaning the entire system, because most of the issues associated with impunity are systemic in nature. So if the state makes a commitment and also ensures that violators of rights and also perpetrators of torture are brought to book, then that will go a long way in ensuring that we uphold the principles of fair hearing and all the other provisions of the law as stated earlier in our discussions. I also think that the security agencies themselves need to streamline the operations in a way that there is no gray line when it comes to the criminal procedure. If the operations of the different agencies are not streamlined, then that is one of the drivers of impunity, because at the end of the day, even when the well-thinking members of the forces, as my brother Elison spoke about, that there are those who have given themselves to public service. So when people like that really would want to take steps to hold people accountable, it becomes very difficult because there's a gray line between the different agencies. So I believe that is something that should also come from the leadership, unfortunately, of the security forces. We must see that commitment at all times. We also need to ensure that there's rule of law in this country, because over and over again we have seen the erosion of rule of law, and we apply the law when we deem fit, and we often the concept of justice has over time really been like one where it is at the mercy of whichever component of the justice sector you find yourself at. So I believe that because we already have a robust legal framework that really gives us very clear confines within which Ugandans can access justice, it is our duty to ensure that the law takes its course as it is. Of course, we know that most of our officers who are in these different agencies undergo trainings, but I also believe that there is need for more capacity building, especially for our security agencies. Most of them need to be grounded in the element of human rights, on issues of access to justice, and on different confines of application of the law, so that while they go about their duty, they are very mindful of the perimeters within which they can work. Ultimately, at the beginning of this discussion, we talked about the huge gap that we've seen, especially with the non-appointment of a chairperson of the Human Rights Commission. That means a lot for us as a country, because whereas every day you're watching the news and you're seeing so many allegations of human rights violations, it becomes very difficult, for people to be held accountable. It becomes very difficult for Ugandans to seek redress where there are human rights violations. I want to recommend that the state takes urgent steps to ensure that we have a chairperson of the Human Rights Commission appointed, that the Human Rights Commission investigates these allegations and also comes up with robust recommendations that can enable Ugandans to live harmoniously. And that's not to say that criminals should be excused from the crimes that they've committed. What we are saying is that everybody has a right to a fair hearing, and that we should let the law take its course in all circumstances, regardless of what it is.
Thank you very much, Mase. And I would want everyone to all you panelists to have a take on this area. Jude, you were away when I think you were off, so I want you to just share with us what are the best safeguards for the rule of law and the protection of human rights in Uganda.
Hello. When we talk of the best safeguards, at a very theoretical level, I could simply say if you have an independent judiciary, it's very easy to have a rule of law. But I think the most important safeguard for the rule of law is a culture of accountability. When the people who yield power and authority recognize that they are accountable to the general population, they are accountable to various state organs, it's very easy for them to have respect for the rule of law. And so for me, that's the most important safeguard that we can think about. Obviously, having an independent and empowered judiciary also goes a long way in ensuring there is respect for the law, because the judiciary is the body that is charged, that arm of government that is charged with ensuring that everybody is operating in accordance with the law and nobody is above the law. And that's the role of the judiciary. So to have respect for the rule of law, the most important, among the important safeguards are the judiciary, having an independent, well-funded, and impartial judiciary. That's very important. One of the challenges I think we have, for instance, with the judiciary is the funding and its capacity. If you are going to have a ratio of one judge to almost 500,000 people, obviously, it's difficult for the judges to be able to dispense justice. And the general citizenry, the ordinary people, are also an important safeguard in ensuring the rule of law. Because if the ordinary people are so convinced about the importance of the rule of law, they have also got ways in which they can ensure that their leaders respect the law. First of all, to an extent, there is the power of the ballot, which the ordinary people can also choose to use to ensure that elected leaders respect the law. But if we maintain a culture where people who break the law are sort of endorsed politically by the electorate who continue to elect them into offices, in a way, it's an affront to the rule of law, because people will develop a belief that there are people who are so powerful that no matter the law, they can have their way. And that sort of culture can only be broken by the ordinary person, by the decisions made by the ordinary people at the ballot, and of course by organs which are supposed to be independent, such as the judiciary.
Thank you very much, Jude. I want to invite in Elison to have your take on this.
To have my take on safeguards for the rule of law.
Yeah, the best safeguards for the rule of law and protection of human rights in Uganda.
I am, first of all, I think that obviously you need to have a strong and independent judiciary. You need to have a informed and empowered citizenry. But also the concept of what we call rule of law must not be turned into an idol with which that people go stabbing in the back. So we need to make sure that it is a concept that is properly understood, and not an idol to which people are paying mere lip service. The other point is that we should discourage people from treating the security services as though they are opponents in the war for the rule of law. The security forces are an instrumental part of the rule of law, and winning them over to understand the sort of lines that are being pushed is very, very important. Some years ago, the Uganda police introduced human rights, for example, in its training. People like detention beyond 48 hours, I think, became a cost issue even for the police. How are you keeping those people? Steps like that to ensure that there's even now, I believe, a human rights directorate, legal and human rights directorate of the Uganda police force. It is important, especially for civil society, that the advocacy should not just treat the security chiefs as enemies in the war for the rule of law. I can tell you that if the security establishment adopts a posture of being passive towards lawlessness, or being extremely active in human rights violation, to be bad for us either way. So it's important that they are seen as partners, not as enemies or warlords. I think warlords are people who control territory in Somalia and tax the ships, and they are not here. That is one way of doing it. The other way, of course, is we must ensure that the courts must also, you see, a security officer who is recruited from the public, if he had been a member of the public and the public had caught a thief, or a person who, if a person shot at General Katumba and somehow fell off and was disarmed, the justice he would get from the population at the point would be quick, would be swift, would be merciless, and would certainly not appeal to any of the tenets of the rule of law. The security officers come from that population. By the time he joins the security establishment, he already has a certain understanding. So we need to spread the whole concept beyond just the security establishment. And the same is true of the judges. I mean, you go to courts where suspects coming out of a prison van are squatting. I mean, as someone talked about dehumanization of an accused person, the man is on trial. He is innocent until proven guilty. But before he gets into the court, he is told to first squat and wait for the majesty, the lordship, the worship of great stature to come in. That culture means that even the person who is observing that squatting may not be as alive to his human rights as you imagine. So human rights needs to really be inculcated in us. Its values need to be spread out. The evangelists need to do a better job of evangelizing. They need to be, the people who are the apologetic liars of the human rights movement need to ensure that they spread the gospel properly without alienating, but by increasing and by building up. The issue of the political leaders is also there, but I think the most important thing is that we must have a culture of respect of human rights and a culture of the rule of law inculcated in the judiciary. Because I think that there are very many independent judicial officers who don't really hold some of the views that some people hold. So in the judiciary, in the public sector, and in the security services. But all those officers in those places must be recruited as allies, not as enemies, and must be brought on board, not alienated. Certainly, the torture, for example, of the suspects of General Katumba was wrong. But at the same time, the argument, the converse argument, that once that happens, the rule of law means that a passive posture must be adopted, and someone who has been accused of such a heinous crime must not be given his day in court to answer whether or not he committed this crime. I think would not do very well for the rule of law or for the establishment of human rights. The active and passive postures, active in violating rights and passive in living crime. That binary choice must be known to be a false choice. That human rights include victims' rights. That human rights accountability of security also includes accountability of suspects. That it is wrong to beat a suspect, and it is wrong to kill a person. It is wrong to commit a crime, and that that two wrongs do not make a right. Beating him does not make it right, and you shouldn't make it a right even on the other end. I think that binary choice, for me, does not represent an advancement in human rights in Uganda or anywhere else.
Thank you very much, Elison. I would want to invite you on this one also, but while you're on, you also need to give your parting shots because our time is spent. So after that, I'll give one of us 30 seconds to conclude on this. Sarah?
Yeah, Demian, I want to first state that the principles of rule of law that should be promoted include supremacy of the law, equality before the law, accountability of the law, and fairness in the application of the law. I think we should all promote these principles in our campaign to promote the protection and observance of human rights in Uganda with the rule of law as a cornerstone. On the safeguards for rule of law, we need to understand the links between rule of law, quality, and people centricity in justice systems, including access to justice that is still a nightmare for most Ugandans. We need to deepen good governance because you cannot promote rule of law in isolation. Then independence and efficiency of courts and institutions of governance. And lastly, we need to build trust and confidence in government institutions. You know, there's a situation where citizens are becoming very suspicious of anything to do with the government, including beneficial programs. You know, the confidence by the people in government has been eroded by a number of actions, and impunity will only worsen the situation. So I think we should all, as a collective, work to fight impunity, growing impunity in this country. I did refer to security chiefs at several levels, really, that conduct crimes like kidnaps, torture, murder of suspects as warlords, because they operate outside the constitution and laws of the land. All government agencies are enjoined under Article 20, Clause 2 of the Constitution to protect, observe, and promote human rights. And there are several articles that follow that article. So when I have a head of a government department that sanctions kidnaps, that sanctions torture and murder of citizens, in abuse of the Constitution, in abuse of other related laws, I mean, how different are they from warlords? And Demian, that is my parting shot as well.
Thank you very much, Sarah, on that one. Let me invite in Mercy to give us your parting shots in the 30 seconds.
Yeah, thank you for having us. I think I pretty much did my parting shots in my last submissions, but I just want to re-emphasize that issues of respecting rights even be issues that we should be compelling our state to do. They should be something that comes natural to the state, and they should be the priority of the state to protect and promote the rights of its citizens. It's doable, and I think violations in this country to go a long way in building citizens' confidence in the systems that be. Thank you very much, Demian, and all the colleagues who have been on.
Yeah, thank you very much, Mercy. Robert?
Thank you, Demian, and thank you, my fellow panelists. I think there's no rocket science here. The Constitution is very clear under Article 20, which says that fundamental rights shall be respected, upheld, and promoted by all organs and agencies of government and by all people. The six of us, as we are here, constitute all people. So let's just abide by that constitutional provision. Two, let's look at the obligations. The primary responsibility of protecting and promoting human rights in this country lies with the state, because it has an obligation to respect, to protect, and fulfill human rights. If we all do what is expected of us, I think we'll have strong institutions and we'll get the democracy that we deserve and the rule of law that we are urging for. So let each one play his or her part, and I think we'll have a better society.
Thank you very much, Robert. Jude?
Thank you very much. I think I'd also really summed up my key points, which were rule of law is something to do with the culture of our people. very easy. We have them is because rule of law, prohibition against torture, they still look like exotic ideas which are struggling to fit within our Ugandan society. And so these kinds of conversations are very important to help the ordinary folk understand why it is wrong to torture a suspect of a crime. Because even the people we deal with, whether it is people in the army, people in the police, they are also people who come from society. And some of their methods of operating are not necessarily learned from the army or the police. It's how the ordinary folk would also probably deal with the suspect. So it's also partly a cultural issue, and we have to understand some of these issues in that context and emphasize that even the suspects of crimes have a right to be treated with dignity. That's what I consider to be my parting shots.
Thank you very much, Jude. Then finally, Elison.
Thank you very much for the opportunity to be here and for the conversation that we're having. I think as my parting shot is that the rights of the individual are important. The individual is sacrosanct in his rights, in the enjoyment of those rights. And the purpose of a free and democratic society is that people are able to prosper, are they able to work together, move freely, think loudly, and operate within the ambit of the law. The legal principles established over centuries for liberal democratic dispensations are that the individual must be free to do everything he wants except that expressly prohibited by law, and the state must do nothing except that expressly permitted by law. To that end, I am a firm and strong believer in that rule of law and in people being held accountable for violating the laws of the land. But I am not such a skeptic or critic or cynic on the security establishment in Uganda. I, for example, told you that I'm not from my head. I have not seen an equivalent of the trial that we had for the World Cup bombers. I have not seen extradition requests across countries to try terrorists. I have seen illegal rendition. I have seen international assassination. I have seen people and I think that we are not there, but we are somewhere, and we need to push ourselves to be where we are. But we don't need to deny where we are and dismiss the people who are in charge of the security. I insist, as warlords. We have had warlords here. We have had a time when this town had 5 different armies controlling it. And at that time, there were no extradition requests for the likes of Jamil Mukulu. At least now, Jamil Mukulu can be happy that it is Uganda he had rebelled against. Had he rebelled against the United States of America, there would have been a bullet in the middle of his head, and he would currently be resident in the deep blue sea, like his friend Osama bin Laden. So at the very least, we should give ourselves a little bit of pat on the back and then encourage those in security to do better, to move further, and to move faster. We are not where we should be, but we are certainly not where some people are claiming that we are. Thank you very much.
Indeed, it's work in progress. Thank you very much, Elison, Jude, Mercy, Sarah, my analyst, Robert. Thank you for attending, and also our viewers out there. Thank you very much for being part of this conversation every Friday. And I hope we can meet again next Friday. This is the Citizens Chat Show. Follow this discussion on our Twitter, on our Facebook, on on our YouTube channel running live. I want to say thank you very much for our panelists and also the viewers out there. We meet next Friday. This is the Citizens Chat Show. My name has been Masesa Demiano as a host.